There are two common causes. The most usual one is rent arrears, and the other one is dilapidation claims. Rent arrears is straightforward. The tenant isn't paying their rent, or other rent issues are that the landlord is trying to raise the rent to a level that the tenant does not agree with and thinks is too high. So those are the two issues that arise in commercial property about rental issues. Dilapidations is repair to the property, and that'll be an argument either from the landlord that the tenant hasn't repaired the property as he should have during the course of the lease, or when it's the tenant wanting to vacate the premises, what has he really got to do and what can he get away with not doing? It's a breakdown in the relationship between the landlord and the tenant, which is not helpful when you want to continue with a healthy working relationship with someone who you're paying rent to on a regular basis. And when you've got issues with the lease or any obligations that the landlord might have to the tenant or the tenant might have to the landlord, that those are being complied with. If you've had that breakdown in the relationship, it makes it more tricky. Negotiation and talking prior to the dispute getting out of hand. Most definitely. If you want to ensure that that dispute does not last a long time, and you're spending less money on solicitors and other professionals such as maybe accountants you might need or surveyors, if you haven't given them all the relevant information, then they're not in a good place to be able to advise you. And your solicitors and maybe the surveyor will have a look at that documentation and let you know what it is you need to disclose during that process. You may have to go to court, but you could consider alternative dispute resolution as an option. Now, there are various different formats for alternative dispute resolution, but the most familiar one and known to most people is mediation. Now, I'm a firm advocate of mediation, being a qualified accredited mediator, and I always think that if you are able to continue that negotiation throughout the whole process, there is a real possibility that you can avoid any court proceedings. So ultimately, if you aren't able to reach an agreement, then yes, your recourse is to the court to get that determination, but you should always be looking to negotiate throughout. An expert witness is an outside professional who will assist you in giving evidence that will enable the court to determine your dispute. However, having said that, you may well need an expert prior to the court proceedings being issued. Normally, you would get an order from the court for an expert during litigation, but in this particular type of proceedings, sometimes it is essential in dilapidations claims, and in particular to avoid proceedings if possible, to have an expert surveyor come in and to value the level of dilapidations. And it's normal for both parties, a landlord to have a surveyor and a tenant, and then those surveyors meet together in an attempt to narrow the issues or try and reach an agreement. And it's only when they have failed to reach an agreement that we then take court proceedings.